Secretary of State for Housing and Communities, Local Government and Others, Part 1.
Thank you.
Do you want to mention?
Yes.
My Lord, can I hand up, please, 3 copies of the Clark case?
Oh, yes.
It's a report in the Journal of Planning, I believe. Certainly, in relation to the Court of Appeal's decision upholding Mr. Heskey's
Thank you. Thank you so much. Thank you. So this was, do either side actually want us to read this before we go any further, or
not? Neither, I think. Thank you, my Lord.
Thank you very much, Mr. Willis. Yes, Mr. Mould.
My Lord,
Can I just, before we launch into the next phase of your submissions, say one thing which may be opposite here or may be opposite somewhere else actually, but I'll say it now. We are, among other things, very keen to be absolutely clear what it is that the Secretary of State contends is the justification for the policy.
Yes.
And we need to isolate exactly the references that you would wish us to focus on in doing that exercise.
yes.
Now, that's not, I don't ask you to do it straight away this instant, but simply to have that in mind as you go.
Yes, yes. I had sought to encapsulate that
Yeah.
in paragraph 38 to 40 of my skeleton argument.
Right.
And I had done so having set out some passages from the consultation document that I think you were shown yesterday.
Yes, indeed.
I don't know if the court wishes just to remind itself of those paragraphs.
Well, if it's not inconvenient, it may, since we've got our minds onto this question
Yes.
straight away, why don't we do that now if it's not going to throw out the train of your submissions?
Yeah, by all means.
So should we have in front of you, of ourselves, the skeleton argument?
Yes, please. The skeleton argument, page 11, paragraphs.
Yeah.
Well, perhaps paragraphs 36 through to 40.
Yeah.
I'll just pause a moment.
Right. Well, shall we just read our way through those paragraphs?
Yes, of course.
Again. Thank you. Right. Thank you, yes.
It was expressed in the consultation document, as you saw. We'll go back to this in a little later. In the consultation document, the reasoning was expressed under a heading, fairness, I think, in the planning system or something to that effect.
Yeah.
But obviously, in order to understand what it was that was driving a narrowing of the definition of Gypsies and Travellers in the 2015 document, under that heading of fairness, one needs to understand what the purpose of that definition was. What role did it play in the policy statement for which it defined a target group? And the purpose was to, as in the mind of the Secretary of State, the purpose was to ensure that to give a greater degree of definition to the target group, focused on the functional the function or the habit of the nomadic habit of life, recognizing that unless in any given case that habit of life was clearly evident, then the purpose for which the special policy regime existed was absent or didn't arise, and therefore it was right to distinguish between those who either actively pursued a nomadic habit of life, or if they didn't do so at the date in question, the evidence was clear that they had ceased to do so only temporarily with the intention of resuming, to distinguish between that class of persons and those who had, for whatever reason, ceased permanently to pursue that habit of life. And in land use terms, that was significant because the former class had certain land use needs that merited special attention, and the latter class essentially formed part of the, in land use terms, the settled population, albeit that, of course, it may well be that they would wish, in many cases, to live in caravans, as indeed do some members of the settled population, rather than in conventional bricks and mortar accommodation.
Yes, and if we were to ask a slightly more refined question, which might be this, if we want to isolate the justification for changing the policy from what it was to what it became, where exactly would we find that?
You'd find that that's essentially in the same analysis, because what the Secretary of State, what the government understood, was that because there was a degree of confusion in this sense, that the former policy definition had led to the special policy regime resulting in planning permissions being granted for those who, although they might be ethnic Roman Gypsies or Irish travellers, had permanently ceased to travel nomadically, that created a source of resentment, because the feeling was that, certainly in a number of cases, the planning permissions in question would not have been available to members of the settled population who essentially were simply seeking a place to live. I mean, that was the thinking, that if you permanently cease travelling, what you seek is a place to live. And that there ought to be clarity and consistency, and that in land use terms, those who had permanently ceased to travel were more clearly aligned to the ordinary settled population in terms of their the choice of their mode of living, rather than aligned to those who actively pursue a nomadic habit of life. Now that essentially is the rationale in the two paragraphs that I have quoted in paragraph 37 of my skeleton argument.
The judge also uses the expression land use.
Yes.
Is that anywhere in the consultation document or the PSED analysis?
I can't recall whether that phrase is specifically used. I'm going to take you to the...
I mean, I couldn't find it, because obviously one of the complaints is that the judge identified an aim which is simply not in the contemporaneous document. So I was looking just simply for the words land use.
Well, we are... The response to that surely is this. We are in the field of land use policy. I mean, planning is about land use. It's about identifying, making policy choices about ensuring that the land resource that is available in this country is put to uses which are best suited to it, and that people's land use needs are addressed in policy terms in a way that is appropriate to them.
Yes, but
so it's all about land use.
But resentment about somebody getting planning when somebody else doesn't isn't to do with land use. Maybe a entirely fair, separate reason. It's not to do with land use.
Well, it is, ultimately, with respect, because if the resentment arises from the fact that a policy is being deployed to enable land to be used by somebody who, on analysis, ought not to enjoy a policy preference in relation to the use of that land, then it is to do with land use. The resentment arises because on
I'm bound to say, Mr. Mott, if that was the justification, I would expect to see that spelled out somewhere in the contemporaneous kit.
Well, I'm inviting you...
A very generalised reference to fairness. On the face of it, just doesn't cut it, does it?
Well, paragraphs 2, 3 and 2, 4, if it were only a reference to fairness, if there were simply a sentence saying the current situation is unfair and it needs to be rectified, I would find it difficult to quarrel with your lordship's approach. But paragraphs 2, 3 and 4, which are we'll come back to the page in a little later, but those paragraphs are to do with the treatment in land use terms of the development of land, which is to do with land use, the development of land, and the policy which identifies preferences in relation to the development of land, on the basis of characteristics, i.e. nomadism or the lack of it, and whether that policy is being applied in a way that is consistent. And
I'm sorry to interrupt, Mr. Mill, this seems to me, to put it in rather stark terms, that having had the nomadic way of life for, let's say, 65 years, your land use needs change overnight when you suffer some medical problem and are told that for one reason or another you can't travel anymore, or it's most unwise to travel anymore because you need to be within 5 miles of a hospital or something like that.
yes.
And where's the evidential base about that? There's a lot of talk about resentment in the documents we saw yesterday, and perhaps you'll show us others. I haven't for myself seen anything other than an assertion of a feeling of resentment rather than any evidential base. But where's the evidential base that the land use needs change?
There's no evidence based on survey or anything of that kind.
No, but even a case study.
No, I accept
because
that.
you conceded a moment ago that although they may not be travelling anymore, they still have a strong imperative to live in a caravan. So where's the basis for saying the land use needs change, if that's the justification for it all?
The basis for that is the long-standing recognition, which one sees in Wrexham, and I'm going to come to this, the long-standing recognition that a nomadic habit of life does carry with it particular needs which don't arise in the case of conventional residential living.
I follow that with respect. But given that those needs have arisen for, in my example, 65 years, what's the basis for saying they disappear overnight?
It's a judgment that the government has made based on the fact that once one ceases permanently to travel, for example, one doesn't need a place in which to store one's work implements, which form part of an essential part of a nomadic existence. One doesn't need to be able to store, to have a place in which to keep a touring caravan which you use as part of your itinerant lifestyle, both for not only for travel in itself, but also for work, to go and lay tarmac or to carry out the conventional and traditional work that nomads, whether they be ethnic gypsies or travellers or otherwise, have carried out in this country. So it's a judgment based on that.
Right. So not evidence.
No, it's a judgment based on past experience, effectively.
I'm sorry to be slow. How can there be any past experience if the past experience was of a policy which provided for those who had permanently ceased to travel?
Well, one goes back. I mean, I don't want to fence on this. There is no evidence that I can point to of survey, or as you put it, case study. I don't have any evidence in the bundle which says we have looked at a number of cases of those of gypsies and travellers in the broadest sense who have been actively nomadic in their habit of life, but who have ceased because of old age. We don't have any. I don't have any evidence of that kind of case study. So necessarily, it is a judgment informed by, we are told in the documents, a perception of that resentment has arisen in the way in which the planning policy for Traveller Site and previous policies which seek to facilitate nomadism have been applied in the past, and that has given rise to resentment. And when the consultation document was published and the consultation and responses were received, as you saw yesterday, there were a wide range of responses, including support for the change on the basis that it would create a fairer system. So I've taken you to the consultation document which set out the government's proposed policy. When we come to the response document, we see that the proposed policy and the stated basis for it did enjoy a measure of support. Of course, it also enjoyed a measure of opposition.
Yeah.
But then that simply brings us into the field of socioeconomic judgment that Lord Reid said the courts need to be wary of getting too far into. Because
if we conclude that is what we're in the field of.
Well, there's a distinction to be drawn between the legitimacy of the aim and the balance to be struck, the proportionality balance. As I understand it, my Lord's question is about the first of those points. It is what is the aim, and we've now moved on perhaps through my Lord's question as to whether it is legitimate or whether there's any evidential basis for it. My Lord Justice Coulson's question may well arise in the context of the final stage of the analysis, which is proportionality, but I'm going to come to that later.
No, I understand.
Sorry, speaking as a well, I'll say it as a planner. Wasn't too difficult, was it? Speaking as a planner, I would ask the question, I think, where do we find resentment within the frame of material planning considerations, if I can put it like that? I ask the question because you volunteered that word several times. To help you, let me contrast resentment as a human emotion, if you will, with the objective fairness of a system in which there is a constrained resource, that is to say pitches, for example, which must be prioritised for those who are travelling, which is a proposition I think that is certainly beneath the surface here, if not actually on the surface.
Yes.
There are maybe two contrasting things, or maybe you say they're really one and the same, or one is a manifestation of the other. But for my part, I'd just like to bring this back to planning, if you'll forgive me.
Well, I share your Lordship's pain in that respect. Can you
help the court?
Yes. Well, resentment in the sense of simply of a human emotion, that is to say, I dislike the fact that somebody has built a house next door to my house when previously I had a lovely view over the countryside beyond, and now I look onto my neighbour's back garden. That is not certainly one should be wary of saying never, but that is not in the great majority of cases, as we know, considered to be material for planning purposes. If government is considering whether its current policy position in relation to planning matters is operating in a way that carries popular support, and therefore carries, if you like, endorsement, which is a perfectly proper political consideration. then if there is evidence that its current policy framework lacks support with a section of the community, and it can see a way of resolving that lack of support, or put another way, resentment, through adjusting the policy so as to make it clearer what its target beneficiaries are, and to make provision for those who perhaps have been, to address the confusion that may have arisen and which may have given rise to the resentment in another way, then that would be a legitimate and rational approach to policy making. And that, in effect, on my case, is what has happened here. Now, that doesn't address my Lord's question, well, where's the evidence for it? But it does at least provide an answer to how resentment per se might not be of any great significance, but how it might, in the mind of the policymaker, be a motivating factor in reviewing the policy and seeing whether it can be adjusted.
At the end of paragraph 38 of your skeleton argument, you say, there is evidence in responses from local planning authorities in particular that this inconsistency in planning policy, or quotes unfairness, those quotes, was a source of tension between the settled and traveller communities. And that encapsulates, does it, what you mean by resentment in this context?
Yes. And I am seeking to, in those paragraphs, I am clearly, as an advocate, seeking to explain to the court my own understanding of the rational basis upon which the policy change has been put forward. And so it's unsurprising if you don't find precisely that language in the documents themselves. But that is not in itself a source of concern, because after all, it is the task of the advocate and ultimately of the court to seek to understand and express in its own way what it considers to be the logic of the policy change and the reasons for which it is being made. And the fact, and where I refer there to evidence from local authorities, I of course am again referring to the responses that are recorded in the consultation response document. One doesn't have specific responses in evidence, but one has a summary in that document, and that stands as evidence. The weight to which one attaches to it is entirely a separate matter, of course, and the court will wish to consider that. But it's undeniable that on the record that responses from local authorities were found to express a certain point of view.
Mr. Moll, I completely understand all of that, and I appreciate it's a bit of a fine line sometimes between explaining something in simple terms to the court and looking back at what is or is not in the documents. But I think it's also right, isn't it? Questions of confusion or inconsistency, also those concepts aren't expressed in
They're not expressed,
the contemporaneous documents.
I seek to suggest that that is an apt. There's an apt nouns.
Because there wasn't any confusion about the policy, the 06 policy continued in 12, that if you'd ceased travelling, whether temporarily or permanently for those reasons, you were covered.
No, that's true.
Other people might not have liked it, but there wasn't any confusion about it.
No, I accept that. Yes, yeah. Yes.
Yeah.
Yes. What I was, I was going to move on to ground three, and we've, in a sense, your court is ahead of me because these questions have been about that. But I wonder if I might, I hope without undue repetition, just make the following submissions to you. Yesterday we saw that the limit of the change in definition of gypsies and travellers between the 2012 and the 2015 policy statement was as follows. The change was limited to those gypsies and travellers who had ceased permanently to travel nomadically by reason of their own or their families' or dependents' educational or health needs, or old age. I can explain that in this way. In the 2012 definition, that class of persons was included within the policy definition and so fell within the scope of the policy. Whereas in the 2015 definition, that class of persons was excluded from the policy definition and so fell outside the scope of the policy. In the 2015.
2015,
Yes.
I thought you said 13, yeah. 2015, that class was excluded.
Yes. That is the extent of the change.
And do you say that's, what do you say about the extent?
The
Big extent, small extent, narrow extent?
well, it's more limited than perhaps might have been implicit in some of the submissions made by Mr. Willers yesterday, which focused on ethnicity, for example. There was no question of the 2012 definition, as I submitted yesterday, bringing within its scope ethnic Romani gypsies who had ceased permanently to travel for any other reason.
I just indicate, my lord, that if that was a suggestion that anybody took from my submissions, I would like to make sure that everybody appreciates I'm not arguing for a wider scope than the definition should cover those who have ceased travelling for as a result of force of circumstances.
So a reversion to the previous
Yes.
policy.
At no point in my submissions did I ever suggest that it should go beyond that.
No.
But Mr. Mole's point is still valid, that you are saying that it's more limited than it might have been.
Yes.
But in one sense, in the end, it gets everybody. Unless, as a gypsy or traveller, you're prepared to die on the road,
No.
it gets them all. Because regrettably, we all get older.
Unless,
Even Court of Appeal judges.
it gets all of those who have not chosen to
Exactly.
cease. Yes. So it
You
extends.
carry on till you drop.
Yes. If you're determined to pursue the nomadic habited life until you are, in the general sense, disabled from so doing, whether by virtue of your own health or through the imperatives of educational or health needs of your or age of your dependents and family, then I accept that proposition.
Yeah.
Right.
This picks up on another submission, which I may have misunderstood, but if I have, forgive me, yesterday. It does not follow that those persons' accommodation requirements, by which I mean those who were previously included but now are excluded, taking my Lord's point about who ultimately will fall within that class, does not follow that those persons' accommodations requirements were consequently ignored by the planning system. And I draw attention to the National Planning Policy Framework. If I could just invite you to turn to that. I don't think we've seen that hitherto. It's in the authorities bundle, tab 23. Page I want is page 704, and the National Planning Policy Framework, as the name implies, provides the planning policy framework for planning and decision taking in relation to the full range of development that is required in order to meet the nation's socioeconomic needs. And Chapter 5 is concerned with the delivery of a sufficient supply of homes. Paragraph 60 indicates the government's objective, which is to significantly boost the supply of homes. It says it's important that a sufficient amount and variety of land can come forward where it's needed, that the needs of groups with specific housing requirements are addressed, and that land with permission is developed without unnecessary delay. Then it goes in paragraph 61 introduces the concept of local housing needs assessment, and 62 then says within this context the size, type and tenure of housing needed for different groups in the community should be assessed and reflected in planning policies, including but not limited to those who require affordable housing, families with children, older people, students, people with disabilities, service families, travellers, people who rent their homes, and people wishing to commission or build their own homes. Now, the footnote 27, as you see, says planning policy for travellers' sites sets out how travellers' housing needs should be assessed for those covered by the definition in Annex 1 of that document. But plainly, those who are ethnically Romani Gypsies or Irish travellers who don't fall within that definition, they must have their housing needs assessed and appropriate provision made within the scope of paragraph 60 and 62 of that policy framework. And that was the government's intention, is confirmed by the written ministerial statement that you may have seen mentioned in the evidence. You have that at page 85 in the supplementary bundle.
Yeah. Should we look at that then?
Yes, if I may, just take you to that briefly.
Are we putting away the NPPO?
Yes, yes, I think so. Thank you. I mean, as your lordship knows, and but I'll just make a point. That chapter then, of course, goes on to make a very detailed, set out a fairly detailed framework as to how development plans should be prepared in order to achieve the government's objective, and then sets out policies in relation to decision taking on housing and applications for housing development.
Yeah.
Mr. Mill, just before you move on, confessing my own ignorance of Chapter 5, does it follow from what you've said that following the change in definition in 2015, local authorities in assessing housing needs in their area should have taken into account a new group,
yes,
namely those now excluded from the definition, ex-travellers, to use an inelegant shorthand?
it does.
So previously they had, let us say, a duty to consider the need of 100 persons who came within the 2012 definition. They now must consider the needs of 50 persons who come within the 2015 definition, and another 50 who no longer come within it, but still want to live in caravans.
Yes, so the 100 would still, the policy, taking as a whole, that is to say, the National Planning Policy Framework read together with the Planning Policy for Travellers' Site, policy is intended to fulfil, has the objective of seeking to meet the needs of each of those 100 people, but it does it in a different way in 2015 to the way in which it did it in 2012. That's the point.
But how does that translate into a loss of caravan?
It implies that the delivery of sites in accordance with that overall policy framework has not been successful, and that there is work to do to improve on the position. Because there's clearly a distinction to be drawn between the policy framework which the government has in place, which seeks to achieve an objective, and the operation of that system and the delivery of sites in accordance with it.
So is there any objective monitoring of the performance of this policy?
There is annual monitoring of the supply of sites, which includes, just bear with me, it's in the, and there's an example of this in the,
because the policy's been in operation now for what, 7 years?
Yes. I just want to make sure I get the count for you. I'm sorry. I think it's tab 27 in the authorities bundle. Tab 20.
20.
Yes.
We'll come back to the ministerial statement, of course.
Yeah.
We've forgotten that. So we'll keep that open, but you want us to go to...
tab 27. Page 6. The number's hidden, I'm afraid, in the text, but it's page 758.
Yeah.
So that count, that's published annually. Now, what I'm afraid I think that may be focused on sites that would fall within the PPTS definition. I'll confirm that for you before the end of the morning. But so I think is the current monitoring. Would you just allow me a moment?
Of course, yes.
I'm going to check on that because I think the answer to the question is that there isn't monitoring of that class on a national level. But I will confirm that.
Sorry, which class specifically?
The class you asked me about, which was those who fall outside the scope of the. Yeah. But I've just asked.
Yes, in a sense, it's both, I suppose. One is the corollary of the other.
Yes.
Necessarily. So, whether the policy has had its predicted and intended effect is not at the moment a matter on which we have any objective evidence.
No.
Right.
Not from the evidence you have is the evidence that I think my Lord, Lord Justice Holroyde was referring to, which suggests that there is a persistent shortfall in supply. Yeah.
And you've got nothing to present to us to gainsay that?
No.
Right.
My point, my submission is on the policy framework which is designed, at least in policy terms, to achieve.
Yes. I mean, in a sense, what we're asking for is beside the point, because it's not within the compass of the proceedings, the argument anyway. But it is instructive, I think, when a policy's been in place for 7 years, to be able to say, well, has it worked?
Or how is it working?
How is it working?
Yes. I again, I wish there to be no misunderstanding as to my position.
Yes.
My defence of this claim, this appeal, is founded upon essentially founded upon the proposition that the change in definition is a policy change, and it is one that needs to be understood primarily in the context of the broader policy and legal context in which it was made.
Yes.
Because it is intended to set a context in which the planning system should operate in practice.
Yeah.
There is no... I cannot resist the conclusion being drawn from the evidence that's before the court, how shall I put it, that there is, on the face of it, a good deal of work to be done in order to give full effect to the policy objective that one sees, both in relation to those who fall within the scope of the revised policy definition and those who, the 50 people on my Lord's analogy, who now fall outside it.
Yeah.
But my argument is that that latter question is not a factor that ought to weigh significantly in the court's judgment of whether the fair balance has been struck here.
No, quite.
Because we're concerned with a formulation of policy rather than the question of its successful implementation.
Yeah, well, that's why I said what I did just now.
Yes. Yeah. I thought I ought to make that clear.
Of course. Understood.
So the bottom line is they fell outside the specific policy, and they're then effectively caught by the general provisions in the MPPF that you've shown us.
Yes, that is certainly a fair way of putting it with respect. I wouldn't want that to be, in agreeing to that, accepting that, I wouldn't wish to be understood to be diminishing the significance of the NPPF. The NPPF is the government's overarching...
No, I understand that. That was the argument that found favour with the judge below.
Yeah.
I understand that. Yeah. But that's the submission.
That's the submission,
yeah.
Yes. And of course, and as we've gone into the realm of fair balance to a degree, of those factors that I submit, viewed overall, support the conclusion that a fair and proportionate balance has been struck here under Article 14 and Section 19 of the 2010 Act. It is the fact that it's not no provision, it's alternative route, i.e. the NPPF. But the additional factor are those other material considerations that must, as a matter of law and policy, be brought to bear at the decision-taking stage on any application by a now not non-PPTS.
You mean age, disability, and so on?
Age, disability, and the Chapman duty, and so on. And I'm going to come back briefly to just to show you the references.
Could we just turn it round, and I just ask for your comment on this? It might be said, an observer, an informed observer, looking at all of this, might say, well, there's always been a problem with there not being enough sites for gypsies and travellers. A way of addressing that is to reduce the number of people who count as gypsies and travellers for planning purposes.
That I can see that might be a view that might be taken. There is no evidence to support the view, the conclusion that was what motivated the change in this case.
Yeah. And just to take a practical example, perhaps you've dealt with this, and if you have, just tell me that you have. But if you go back to the NPPF, paragraph 62, that paragraph actually is about things that should be done in planning policies. That means in the development plan.
Yes.
It's not specifically directed to development control, i.e. making decisions on applications for planning permission. But insofar as it encompasses travellers, whether or not there is a development plan policy in place for dealing, as it were, with what I'll call the residual, the outside the PPTS policy cohort, those people would have their Article 8 rights considered, would they?
At the decision stage.
At the decision stage.
Yes.
So they, in any event, would have the benefit of that, if you like, differentiation in the operation of the planning system.
Yes. Yes.
In that way, whether or not there be a policy in the development plan that says what it might say.
Yes.
That's right. That's the point you wish to make here. Isn't it? And that is an element in the fair balance.
Yes.
That proposition.
And as we shall see, a point that was expressly adopted in the public sector equality duty analysis in June 2015. I mean, that at the decision-taking stage, as your lordship knows, the significance of development plan policy is that it enjoys a particular role under Section 38(6) of the Planning Compulsory Purchase Act.
Yes.
Because one has to consider overall.
There's a presumption in favour of the development plan.
Taken as a whole, exactly.
Yes.
But we know that in the overall planning balance in any given case, the evaluation of development plan policy against other material considerations is in the hands of the decision maker.
Yes.
See City of Edinburgh,
etc.
etc. And there is no doubt that respect for family and private life, Article 8, the positive obligation, see Chapman,
yes.
The best interest of the child, see Collins, personal circumstances, see Basildon, the need to pay due regard to
Yeah.
protection of protected characteristics, including age and disability, see section 149. Each of those is a material consideration, whether by dint of law or policy or both.
Yeah.
And each, therefore, has to be evaluated.
So in a situation such as the present case, for example, or indeed a local planning authority's decision to grant, but let's say in a decision-making context on appeal, an unlawful failure to have regard to, take into account, act upon as appropriate any of those considerations might vitiate the decision for an individual or a family falling within that residual cohort, i.e. outside the definition in PPTS 15.
Yes. My Lord, yes. That is of the two. Might I just take you to my skeleton argument,
yeah.
Paragraph 11,
Yes.
page 5.
11.
Yeah. That paragraph seeks to encapsulate the line of argument that I've just been developing. A fair balance is struck by two principal complementary factors. Firstly, the National Planning Policy Framework. I've taken you to the references. Secondly, the paragraphs are slightly different because at the time of the argument before the judge, we were dealing with the previous edition. But I can say quite firmly that paragraph 60 and 62, and indeed section 5 as a whole, are not materially different to those paragraphs that were before the judge.
Yeah. So really, paragraph 11 captures
the point.
Captures the exchanges we've just had.
The corollary to paragraph 11 is that in the absence of the framework and in the absence of those legal and policy considerations that the decision maker in any given case is required to take account on the facts as they arise. In the absence of those considerations, the policy change couldn't be said to be justified. So the change in itself is, it's no part of my case to say that the change in itself can be properly justified in its own terms. It has to be, its justification lies in considering it in the context of those two, as I put it, principal complementary factors. Can we just turn to the June 2015 document, which I hope will just make good that it's not just Mould saying that, but it's actually what was in the mind of the Secretary of State.
Right. So back to the decision.
If we go back to the...
You're going to take us, incidentally, to the ministerial statement. Shall
I do that now and then for your notes? And then,
page 85.
Yes, and then I'll go directly to the... I do want to take you to those cases briefly and to...
Of course, yes, but I just wondered whether that was a loose end.
It was. You're absolutely right. It's page 85. It's a very short point. And again, I'm afraid confusingly, it refers to yet different paragraph numbers in the yet earlier edition of the National Planning Policy Framework. Right. But you'll see under the heading paragraph 159, the Minister said on the 22nd of July 2015, Planning Policy of Travellers Site sets out how travellers is defined in Annex A of that document. Accommodation needs should also be assessed. Those who do not fall under that definition should have their accommodation needs addressed under the provisions of the National Planning Policy Framework.
Yeah, which is what you've said.
Which is what I've said. Turning then on, as if it's convenient.
I don't understand that last sentence.
This does not form part.
This does not form part of the changes to the National Planning Policy for Travellers on which the Government consulted in 2015 and to which this Government intends to respond shortly. I think all she was saying is I'm dealing with this specific point, but we'll be dealing with the consultation.
This was July, the policy was September.
Yes, and there'd have been, as you know, there'd been a consultation on the draft policy change.
This was published before PPTS 15.
Yes,
it fully fledged emerged
in August. Yes.
So this isn't. So this is a statement that says that those who fall outside in relation to the NP would be dealt with under the NPPF.
Yes.
As at the making of this statement, that wouldn't have included Miss Smith.
No, because she would have still fallen
Because she would have still been
yes.
within the definition.
Yes.
But post the publication of PPTS 15 in September, 2 months further on, then
She moved from one side to the other.
same statement would apply.
Yes.
In that situation, and this wasn't withdrawn, this stayed online. This is an online statement, I think. Is that
Yes.
right? And this stayed online post September.
Yeah.
When the PPTS 15 emerged.
Yeah, and it is the and it's the basis on which I put forward the point I do. Yeah, yeah. I think it was a sequencing point more than anything. Yes.
Sorry, my lord. I think the ministerial statement was made as a consequence of a decision in the case of Wenman, and you'll see that in the top line of the
Yes.
ministerial statement, in order to clarify the position.
Oh, I see. Yes. Yeah.
So Wenman was a case that raised some question about how travellers who fell outside the definition were to be dealt with.
Yeah.
And about what followed from from an inability to show that one had provided sufficient sites in one's plan to meet assessed need.
Right.
The government thought it right to issue this promptly in the light of Wenman.
Yes.
That's the point.
Yeah.
Thank you, Mr. Willis, for that.
Thank you, my
No,
lord.
I'm grateful for that. That reinforces the point. I mean, one might say that the minister didn't need to say it because one reads what is now paragraph 62, or 60 and 62 of the framework to see, one can see that is what the national policy is. But it's helpful for the minister to have made that clear, because it emphasises the point that the change in definition, which was then in prospect, is not intended to lead to those who no longer fall within the definition by virtue of the removal of the words "or permanently," that their needs should, as it were, simply fall away. Not intended to have that consequence. Far from it.
Right. Yes, you're about to show us something else.
Well, if you turn to page 180 in the supplementary bundle, one has the public sector equality duty analysis in June 2015, which is the revised analysis that was produced shortly before the policy, the revised planning policy for Travellers Sites 2015 was published in August. And you can see that I just wanted to show this because it's the key document of my submission insofar as justification is concerned. And you see at page 180, proposal 1 of the various proposals in relation to the then existing 2012 edition are concerned, to amend the planning definition of travellers, to delete the words permanently so as to limit it to those who have a nomadic habit of life. And then that the equality assessment of that proposal is set out at pages 181 to 183. The proposal is set out the objective to ensure that the planning system applies fairly to all. Paragraph 3, the section 1491 considerations. The things that the proposal does not do. And then we recognise that this proposal will have an impact on the identified racial group, i.e. Gypsies and Travellers. And so, of course, they then make clear, we note, for example, that Romany Gypsies and Irish Travellers are a protected race under the Equality Act. Additionally, within this group, there is likely to be a specific impact on the elderly, disabled and possibly women, particularly those from single-parent families. We recognise that age, disability and gender are also protected characteristics under the Act. So they have in focus
Yeah.
the concern.
You would stress the words additionally and also in that paragraph.
Yes. And we're plainly here concerned with ethnic Romany gypsies in the broadest sense, but as your lordship points out, we're concerned with particular protected characteristics focusing on age and disability. The impacts are likely to be on Article 8, rights to private and family life, home and correspondence. For example, this could mean that those persons without family connections will no longer be able to live with other members of their gypsy and traveller community. Then the balancing exercise is carried out. So Section 4 is essentially the justification over this section and over the page.
So Section 4 is the justification.
Essentially, yes.
Yeah.
Just before we get to Section 4, Mr. Hall, can you help me with the immediately preceding paragraph and the last sentence referring to people without family connections and no longer able to live with other members of their community? As I understood some of Mr. Willer's submissions yesterday, if, for example, it is a condition of occupation of a particular private site that you as an individual meet the definition of a gypsy or traveller, does it follow that there will also be an impact on people who do have family, who do have family connections? Because they won't even be able to live with their family, let alone with members of the community.
If one was to focus on the policy in isolation without consideration of those other factors that I have mentioned, that is to say, particularly the proportionality factors that arise as a matter of law in any given case, it is possible that the strict application of the definition would mean that some members of the family or the extended family group would be able to rely on the specific policy provisions of the PPTS, whereas others wouldn't. But if one thinks of it in those terms, it is obvious that in any given case, the fact that some members of an established family group or broader community do clearly satisfy the definition, and that because they are either actively nomadic or if they have ceased, the evidence clearly shows they intend to resume. It's obvious that that Article 8 and the positive obligation, and indeed those other considerations I've mentioned, would require a very careful evaluation of whether it would be disproportionate to grant permission only in relation to those who fell within the definition, and thus force the family group to break up.
Yeah, well, thank you. I follow that, but I may have misunderstood, so correct me if I'm wrong, but I understood Mr. Willer's submission to be that there are sites where it is a condition of residence,
yes,
that you as an individual must fall within the definition.
And
what you've just said really is helpful if the whole family is applying as a group collectively for planning permission. I fully see that argument. But I'm not at the moment clear in my mind whether this assessment took any account of those people who might not be able to continue to live with their own family. Speaking of myself, strikes me as a pretty heavy impact.
This is the accrued rights point, I think, that I was asked about yesterday. The answer is, this assessment does not specifically consider that question. There is, when one reads the documents that are before the court, that is to say the consultation document, the response document, the equalities statement that is attached to this document, which I'll show you in a moment, and this analysis, there is no express recognition or consideration of the potential for this change in definition to affect the occupation of planning of permitted sites where there is an occupancy condition which restricts occupancy by reference to the definition of gypsies and travellers for the time being in government policy, which I think was the way my Lord put it to me yesterday.
Yes.
There is no, I have not been able to find, I had wondered about trying to persuade the court that one could sort of, by implication, see that consideration, but that struck me as an unattractive line to take. It seems to me that there comes a point in which it is obviously one is struggling, and I don't think I'm able to say that.
Well, it would arise in the enforcement context.
That's the next point. Yes.
Yes. Well, the enforcement context would be this, wouldn't it? That if there were a condition that said that was formulated to tie the entitlement to occupy the particular pitch or the site or whatever it was, to the definition for the time being of gypsy and traveller in government policy, that would fluctuate according to changes in the PPTS, and thus it potentially would be open to a local planning authority to take enforcement action.
It would be.
On that basis, but there again, it would be within the policy frame to which we've referred. There would be a ground A appeal seeking deemed planning permission, and thus would be engaged all the panoply of considerations you've mentioned.
One would expect that certainly. I would certainly adopt that analysis. If one imagines this being dealt with through, as I think your Lordship has in mind, an enforcement notice. So section 172 followed by an appeal.
Yeah, or breach of condition notice.
Breach of condition notice. But if it were the former, enforcement notice, of course, at the prior stage of deciding whether it was expedient to serve an enforcement notice, right, one would expect a planning authority to be advised by its planners and lawyers to think very carefully about the proportionality, or to use the statutory language, the expediency of taking enforcement proceedings in the kind of situation that we're dealing with here. But then, if they did so, as your Lordship, with respect, points out, there would be the opportunity to appeal on ground A. And on that appeal, all of those legal and policy duties that I ventilated would come into play. The breach of condition notice, of course, it's a slightly different regime. Yeah. But the fact that the regime is different, there's no statutory right of appeal against the breach of condition notice. But that would bring into sharper focus in the advice received from planners and lawyers about the need to take account of those factors before deciding that it was proportionate.
Yes. Well, that would be amenable to
judicial review.
Yes.
So the uncertainty
would
would
public lawyers, but getting back to the reality, I think we discussed it yesterday. It's at the very least something that was certain has become uncertain.
I think I offered that.
I was going to say that was your
and none of the points that my Lord and I have just discussed would wholly avoid that.
Such uncertainty is inherent in the policy.
Indeed so. What I can say is that the point doesn't arise on the facts of this case, because in this case, by the time the inspector came to make her decision, the temporary planning permission, which had existed, had expired, and you see that from the decision letter. Has that point? Should I just show you that?
And that was why there was the subsidiary point about the temporary permission being continued,
but that
the inspector said no because they're not gypsies and travellers.
Yes, but that doesn't affect the relevant analytical point, which is this: the concern about that your Lordship raised, and my Lord has raised this morning, the concern that as I put it unintentionally, this narrowing of definition may affect, as you put it, accrued rights. That is to say, the ability to continue to occupy under an existing planning permission which has an occupancy condition. that point the ability to rely on that point fell away in this case once the planning permission granted in 2013 expired. That analysis is unaffected by whether the inspector were to consider granting a temporary permission, a permanent permission now, or an extension of the temporary permission.
Yeah. So the temporary.
It's page 359.
Yes, the temporary permission was 2013 for 4 years.
Yes, and the background is set out very clearly by the inspector in paragraphs 4 to 8 on.
There was a variation in March 2015.
Yes.
What did the variation involve?
It was that was to vary to allow a variation in the permission to amend the site layout. It's paragraph 7, I think, on page 359.
All right, so that's not, we're not concerned with that. That's a change to not to the duration of the planning permission, but to a technical detail of the existing.
Yes. So in terms of this claim, this appeal, where we're left in my submission is this: there's clearly there's no basis on which this court can and should intervene on this Section 288 challenge and grant any relief in relation to this decision on the grounds of the impact of the change in definition in the policy on accrued rights, because that point simply doesn't arise on the facts here. If this court was minded to make observations about that point in its judgment, then obviously that is a matter for the court. But clearly, the Secretary of State and officials will have noted what the court, the debate that has taken place at that point, and I expect that they will want to reflect on that issue, whatever the court may say. But obviously, anything the court says, if it is minded to do so, will obviously be received as very helpful. I hope that leaves that point there. Right. But can I just go back then to the June 2015 document?
The PSED.
Yes.
Yeah.
Right.
At supplementary bundle, page 191.
Yes.
I don't mean that. I mean
181.
181. Yeah. And as I said, the one sees the justification expressed in slightly different ways in the course of the documentary history that you have before you. But the essence of the justification is set out under section 4 on page 181 and continuing over the page. A recognition that there is interference, invocation of the asserted need to secure fairness in the system, reducing tensions you see over the page. These are familiar concepts from the consultation document. And then the invocation of in the first full paragraph on page 182 of Article 8, the best interest of the child. In a case involving families where some members do not travel, it may continue to be appropriate to grant planning permission for traveller sites on the grounds that it is proportionate to do so, and would be an unlawful interference with human rights to limit the permission to particular family members only. As such, we consider that the group of persons most likely to be affected by this change are quite small. Elderly, disabled, possibly women, particularly those from single-parent families without family connections. That point, as I understand it, what is being said there is that one can be reasonably confident that where one is dealing with the potential splitting up of a family group, the consideration of the proportionality balance under Article 8 will lead to a conclusion that the narrowing of the definition shouldn't provide a basis for splitting up the group.
Whether it be quite small or not doesn't matter, does it? in the sense that the principle is what's been stated in the first part of the paragraph. Large or small,
No, I agree.
the individual case which is being dealt with in that paragraph in substance.
Yes, I accept
If
that.
they got it wrong, they got it wrong in estimating that it would be quite a small number of people. The point that matters, you might submit, is that for each such person and their family, the regime described here would apply.
Yes,
Is that right?
that's right. Yes. And then you see the reference to the NPPF.
We're looking at this in terms of justification.
I'm so sorry.
We're looking at this in terms of justification.
Yes.
So most decision makers are influenced by whether they think a change would affect a small group of people or a bigger group, wouldn't they? I mean,
But
isn't that human
yes, but if
nature? If I'm thinking about making a change that affects 2 people in Aberystwyth, I might be more inclined to make it than if I thought it affected 75% of the population.
my own sense is that observation, which is undeniable, is consistent with the point that my Lord has made, because ultimately the justification rests on the fact that whether the group is large or small, the group affected by the indirect discriminatory impact of the policy, the balancing factor that is critical in striking the balance is firstly, well, 2 balancing factors. Firstly, their needs will continue to be assessed under the National Planning Policy Framework. And secondly, and critically on this point, in each and every case, in principle, material to any decision which involves the application of the revised definition is a consideration of their personal circumstances, consideration of their rights under Article 8, consideration of the best interest of the child in the event of and the consideration of the equality's impact, given that they may have protected characteristics. So it does reduce that. However, whilst the size of the anticipated affected body of persons is a factor that will carry some significance with the decision maker, in this case, ultimately it reduces down to the fact that each and every one of those persons, in principle, is able to invoke those concomitant protective.
To which the answer, to which the riposte is, so why make the change?
Well, the change is...
If everybody's covered in every way, then it's a complete shock and surprise that the number of people able to claim the benefit has reduced so significantly. If everybody has this panoply of rights.
Well, the change is made for the reasons.
Back to the fairness. It's back to the fairness
and the
and the balance with the settled community. And this, in a sense, this isn't justification. If it doesn't matter how many people are affected, then the whole of that paragraph is immaterial to justification.
It's not seeking to justify the question whether again, we're back to, in my submission, a distinction between the legitimacy of the aim and whether the impact of realising that aim is disproportionate. The legitimacy of the aim is, as you heard me say in my submission, ultimately a matter for the government to judge. And the government I am able, on their behalf, to say, effectively what they did was to restore the policy position that was before this court in Wrexham. That's what they did. So in terms of rationality and legitimacy, the answer is see Wrexham.
Yeah, well, we've had that debate, and we know, and you very fairly said, I'm not going to fence. We go back to Wrexham without a consideration in the documents of those who, post-Wrexham, had the right, and then had that taken away by the change in 2015.
I've accepted that.
Yeah.
It doesn't arise in this case, but I've made the point that that matter wasn't explicitly considered in this
Yeah.
because it's a forward-looking rather than a backward-looking document. But subject to that point, Wrexham said it is rational and it is consistent with Chapman for planning policy for Gypsies and Travellers, for Gypsies and Travellers sites, to exclude from its scope those who have ceased, for whatever reason, permanently to pursue a nomadic habit of life. That is Wrexham. So on that basis, it is accurate to say that this change that the court is seized with is in effect restoring the Wrexham position.
And what do you say, I understand that, what do you say in answer to Mr. Willer's point that Wrexham was not addressing the Equality Act 2010?
It wasn't addressing the Equality Act 2010, that wasn't an issue. Chapman, as it happened, there is a discussion in the Chapman judgment of Article 14, and the majority in the case didn't find any breach of Article 14. But it didn't. But Wrexham clearly wasn't concerned directly with the issue that is before this court. That issue resolves down ultimately to the question of justification, and it resolves down to the proportionality balance, because that is what Article 14 and Section 19 are ultimately about. And as I said to you yesterday, my case to this court is ultimately founded upon the argument on seeking to persuade you, as the judge was persuaded, that there was a proportionate that this change, viewed in the light of the wider legal and policy context that I have drawn to your attention, that this change was proportionate. The question, why make the change, in that context, is not relevant to the proportionality balance. It's relevant to whether the stated policy aim is one that is legitimate. Yeah. And that's a matter for the Secretary of State, in the knowledge that the change that he was making essentially was one that had, in Wrexham, been endorsed as lawful. The change was to a policy position that had been endorsed as lawful and consistent with Article 8 in the Wrexham case. Yeah. Now, I'm conscious of the time. I haven't taken you to Wrexham. No. There is a fairly full analysis of Wrexham in my skeleton argument in relation to under my argument on ground 4.
Does your skeleton argument refer to all the passages you wish us to look at?
It may not, but would it be convenient if I take you to Wrexham now and just ask you to note the paragraph, rather than taking time?
But just before we go to Wrexham, as it were, can I just be absolutely clear that you very helpfully focus the issue down to fairness and proportionality? Can I be absolutely clear that the paragraph at the foot of 181, beginning "whilst we recognise," is what is relied upon as indicating fairness and proportionality?
Yes, that paragraph, that whole paragraph.
Yeah.
From
down to unbalanced interference is proportionate.
Yes. Yes. I mean, I'm sorry. Forgive me. I may have misunderstood the point. I say that everything that one sees under the heading "balancing exercise and alternative options."
Well, I don't want to take up time, but paragraph 1 says it's necessary and proportionate, and then repeats that. Paragraph 2 points out all the people who will be adversely affected. Paragraph 3 points out in further detail people who will be adversely affected, and says that such risks will be kept under review, which, as I understand your earlier submission, hasn't happened in the last 7 years. And then in the last paragraph, it reiterates that the negative impact, it may help to mitigate the negative impact that those now excluded from the definition will have their position protected under the general provisions of the NPPF, which is why I was just asking you to say, do we look anywhere other than the paragraph beginning, whilst we recognise, to find the justification? It seems, with respect, to rest upon, at the top of page 182, evidence in the form of departmental correspondence and supported by responses to the consultation.
It's yes, and I've drawn your attention to the consultation document.
Yes.
Which yes,
Yeah.
yes,
All
yes.
right.
Sorry, I misunderstood the point.
No, well, my fault for not being clear. Right, off to Wrexham.
So there may have been a cross purposes because I am talking about, obviously justification includes explaining clearly why we're doing it, but also saying, and in doing it, we recognise and have considered the impact that it will have.
Yeah.
And we believe that we've struck a fair balance between between what we're seeking to achieve and the adverse effects that it will have, which is for this court to address. Yes.
Right.
So
Wrexham.
yeah. Which is 19.
Yeah.
The facts of Wrexham are to be found at 618. And at 23, you see the argument put to the inspector on behalf of Mr. and Mrs. Berry was that gypsies who had to give up travelling for good reasons, such as old age, or like Mr. Berry because of ill health, are still entitled to be treated as gypsies for planning purposes. Circumstances have moved on, 6 ex parte given. Sedentary gypsies have now been recognised as a social phenomenon by the European Court in Chapman and the United Kingdom. That point was put to the inspector, but it was essentially the argument that was put on Mr. Berry's behalf in this court, and you can see that in paragraph. The submissions begin at page 621, and submissions of counsel for Mr. and Mrs. Berry begin at 37 on page 622. You see reference at 37, 5 lines in.
So I was just looking at I hadn't looked at the facts before. I see from 22 they could have been accommodated at the council's Gypsy Site. Mr. Berry had refused to move there because he didn't get on well with the other gypsy families on the site.
Yes.
So they had alternative accommodation, which was a gypsy site, notwithstanding the fact that they didn't technically qualify as gypsies.
That was an element of the factual matrix there. Yes.
Yeah.
Yes.
Sorry, and then you took us to paragraph 30.
Paragraph 37 is Mr. Drabble was counsel for Mr. and Mrs. Berry before this court, and his submissions are summarised by Lord Justice Auld in 37 to 40. And you see the emphasis, amongst other things, on the traditional gypsy, protecting the traditional gypsy way of life. In 39, a reference to Chapman, and the submission that that case had emphasised the need to look at ethnic background in the context of Article 8, and at the very end, underline the relevance of gypsy's traditional way of life to the engagement of the regulatory framework. I mean, forgive me, I'm sure the court will look at the way in which the case was being put in detail, but it's clear that at the heart of the argument throughout, from the position before the inspector until the case reached this court, the heart of the argument was that the then current legal and policy definition of gypsies and travellers did and should embrace a person in Mr. and Mrs. Berry's position, that is to say, people who had ceased to travel nomadically on a permanent basis through, in their case, age and ill health.
So you say that the facts are very much in point.
Indeed. The learned judge surveyed the statutory and authority background in paragraphs 9 through to 13 on pages 614 to 616. I mean, really, one has to. The whole of those paragraphs have been sidelined, and one needs to read them all to understand how law and case law, statute law and case law had developed since the 1960s. Mm-hmm. But those cases recognised that to come within the statutory definition of gypsy over gypsy, that is to say, bottom of page 614, a person of nomadic habit of life, whatever that person's race or origin. On its true construction, that didn't require a person to be constantly on the road, as it were. It embraced those who had settled to a permanent base and travelled from that base. See paragraph 11 and the Greenwich case. And it was able to embrace those who settled for a period of time with a view to resuming more active nomadism, for example, once their children had completed school, something of that kind. See paragraph 13. The question was one as to whether the nomadic habit of life had been abandoned. If it had, such a person was no longer within the statutory definition. If it hadn't, then they were within it. And that distinction was drawn was deployed as the basis of then current policy. Paragraph 14, the references to circular. Paragraph 14 on page 616. The reference to circular 2 of 94, that was the Welsh Office equivalent of circular 1 of 94 that you have in the paper in front of you, in identical terms. And you see at 15, the circular effectively adopted the statutory definition as understood by subsequent case law for the purposes of promulgating policy for the provision of planning for Gypsy and Traveller sites. The judge, Mr. Justice Sullivan, whose judgment is summarised at pages 620, paragraphs 29 through to 32, essentially held that, for the reasons that are summarised in those paragraphs, for those reasons that that Mr. and Mrs. Berry's position was that they did fall within the statutory definition, policy definition, and in part he based that analysis, paragraph 31, on the reasoning of the European Court in the Chapman case. This court's conclusions in rejecting that analysis are summarised on page 627 and 628 in paragraph 57 of Lord Justice Old's judgment. Might I just invite you to read paragraphs 1, 2, 6 and 7.
1, 2, 6 and 7.
Yes, subparagraph 57, subparagraphs
Yeah.
1, 2, 6 and 7.
Yes, because although it's only subparagraph 2 that's been sidelined, I'm bound to say I thought 57 was the heart of
Yes.
I had read this before.
Yes, I'm certainly not suggesting you ignore the remaining.
No, no, no.
But 1, 2, 6 and 7 are particularly helpful.
There's reference to South Bucks and Porter. I'm not sure now which of the two cases that was, and that was Court of Appeal. It went to the House of Lords.
Yes.
One of them did, anyway. Number 2 did, if not both of them.
This says Potter.
Ah, Potter. I'm sorry, I'm misreading it.
I think it should be Porter.
Oh, you think it should be Porter?
So I am misreading it, but I was right. It is Porter.
My Lord, the reference is to paragraph 36, and that is the reference to Porter number 2
Yeah.
and the reasons.
Well, is
judgment on reasons.
it is a yeah, but this is sorry. It is paragraph 36 in Simon Brown, in Lord Simon Brown's.
20 and 40, my Lord. So
This is all about how you read the decision and whether you need reasons and all of that, isn't it?
Yeah. That's what it's usually cited for.
Yeah.
But I just wanted to be clear. Well, how does this get in any way altered when one looks at it in the light of the House of Lords decision?
I have to confess, I haven't looked at that point, but
Well, it's a caution to ourselves, I think, to look at it, isn't it?
Yeah.
At least.
I don't believe it. It is certainly. There was no suggestion at the time that the House of Lords issued its decision in the South Bucks case that it affected the analysis in Wrexham.
Yeah.
But
I mean, yeah.
I'm very happy to have a look at that, and if there is anything, I can send the court a note, which just to confirm it.
I don't think it's necessary for you
Right.
to send the court a note. We can look at that.
All right. Thank you. The paragraphs I've invited you to read, in my submission, are a further an encapsulation of the principles that I have sought to explain to you in relation to the balance between, on the one hand, policy, and on the other hand, the consideration of other factors, other material factors, such as personal circumstances, convention rights, etc. And one sees, in the interest of avoiding unnecessary time, one sees the more detailed analysis, reasoning in the judge's judgment, beginning at page 623, paragraph 40, the sideline paragraphs, which you see run from paragraph 41 at the top of 623 through to 626, where we've sidelined 54.
All of this, of course, was in the pre-Equality Act 2010
Yes.
Universe. Question: how would the provisions of the Equality Act 2010 have materially altered, if at all, the analysis set out, not merely in 57, but of course in the preceding conclusions running from 41?
In my submission, these conclusions would beg the question whether cleaving to the, or resorting to, the definition of gypsies and travellers for planning purposes that was under consideration by the court, in this court in that case, whether resorting to that definition could be justified in circumstances where the policymaker acknowledged that it would give rise to indirect discriminatory effects on those who had ceased permanently to travel through force of circumstance. And so it would have raised the question that this court has to consider in the context of particularly proportionality and the fair balance. But what it would not have, what it does not, in my submission, what it doesn't do, it doesn't require or indeed entitle this court to take a different position on the rationality and legitimacy of the policy definition that is set out in PPS 2015, nor, and this is the important point, does it enable, is there any reason for this court to depart from the clear judgment of the Court of Appeal in that case, that the policy definition that is now in PPS 2015 is one that has that is justified in the planning context because it focuses upon meeting the needs of those who pursue an actively nomadic habit of life, or if they do not do so at the time of a decision, the evidence is that they will revert to that habit of life after the period of its temporary cessation has come to an end. And you see that in paragraphs 41 and following in the Lord Justice Old's judgment. So
I'm not sure I fully understand that submission. The court in Wrexham was effectively looking at the definition and saying whether or not Mr. and Mrs. Berry fell within it. That was the ultimate issue, wasn't it?
They were, but in order to arrive at a conclusion on that, they were asked to consider whether the definition, what was the purpose of the definition, what was it intended to achieve in planning terms, and they did so.
Yes.
And I say that the identified purpose, which plainly they considered to be a proper purpose, that purpose is essentially where we now are insofar as the aim and purpose of the 2015 PPTS definition is concerned.
Well, in relation to the first point that you made, that it means that we're not entitled to form a different view of the rationality of the definition, which is another way of looking at the aim of the 2015 exclusion. Which bit would you say was binding on that point?
Paragraph 57,
Yeah.
paragraph 2. Which clearly articulates what the definition that was before the court in that case was seeking to achieve in planning terms. And
whether applicants for planning permission over a nomadic way of life, as a matter of planning law and policy, is a functional test to be applied to their way of life at the time of the determination.
Yes.
Understand that? Because that was the question before them.
Yes.
But, I mean, so it's just speaking for myself, I completely understand why you rely on Wrexham, and I completely understand that we have to look at it very carefully to see the extent to which it binds us. But I don't read Wrexham as addressing whether or not limiting planning permission to, limiting the definition to people with a nomadic way of life was justified, let alone questions of proportionality.
Well, I've accepted that it doesn't deal with the question of proportionality as it arises in this case, because it wasn't concerned with the Article 14 and the Equality Act point. So I accept that.
Okay, so
but
it's aim.
If you have if this court is asked is faced with a situation where the judge at first instance has said, I consider that the current legal and policy definition of Gypsies and Travellers ought properly to be understood to embrace those who have ceased travelling permanently through force of circumstance. And I derive support from that, from consideration of recent jurisprudence in the European Court of Human Rights on the application of Article 8. This court says, having looked at the policy, having seen what the statutory definition says, having looked at the case law, having considered its application in the context of planning policy which seeks to support and to promote land for those of a nomadic habit of life, we are satisfied that it does not embrace and the judge was wrong to read it in that way. Surely it is, in my submission, it is clear that the court could not have reached that conclusion without having, if it felt that the policy definition, albeit it relied on law and statute and case law, was one that was illegitimate or perverse, or it was a necessary prerequisite to the conclusion it reached on the issue before it, that it was persuaded that the policy definition, deployed as it was for the purposes of the precursor to PPS 2015, that is Circular 194, was fit for its intended purpose.
Well, I must, speaking entirely for myself, I spend a lot of time seeing whether or not a particular claim falls within or outside a statutory provision. I endeavour never to comment on the statutory provision itself unless there's an attack on it, because it's a matter of construction. This was a matter of statutory construction. And courts are forever being reminded that the last thing you do is to say, well, I don't think much of this provision.
Well, I accept that, of course.
But you say on the facts of this case, given what Mr. Justice Sullivan, as he then was, decided, you say that inherent in these paragraphs, that you want us to study very carefully, you say they must have been going further than purely statutory construction.
In order to found their judgment, they had to identify the purpose of the policy as it was then, and why the policy definition was being invoked in the way that it was. And they explain that purpose in paragraphs 41 to 48. And that explanation is one that is entirely consistent with the explanation that is given for is entirely consistent with the Secretary of State's aim in the present case, which is to return to focusing the PPTS on those who actively travel, including those who do resume travelling after a period of temporary cessation, and to exclude from that from that target group those who, for whatever reason, have ceased permanent travel. That is the point. I accept that the issue that arises for this court's decision in this case was not before the court in Wrexham. Of course, I accept that.
Well, because it couldn't be.
Because it couldn't have been. Yeah.
But what you're submitting is that you look at what Mr. Justice Sullivan decided and look at the engagement with those conclusions apparent in the judgment of Lord Justice Auld, with which Lord Justice Clark, as he then was, agreed, I think.
He did, yes.
That it's clear that those arguments are effectively subsumed or embraced within the analysis of the court in that case, by which we are bound.
Yes.
Mr. Mould, could you just help me with this, please? The court in Wrexham was concerned with a statutory definition which was couched exclusively in terms of the nomadic way of life. And it might be said that stripped down, the decision of this court in the Wrexham case was that nomadic meant nomadic and didn't mean formally nomadic. But what, if anything, do you say is the impact of the development that whereas in the Wrexham case, the Act and the circular both referred only to the nomadic way of life, whereas as we considered with Council yesterday, both the 2012 and the 2015 policies have as their overriding aim consideration of the, quote, traditional and nomadic way of life.
Paragraph 3.
Yes.
Well,
in both of them.
The use of that phraseology cannot have been intended to extend the planning policy concept of Gypsies and Travellers to all those who could invoke the tradition of the tradition of life as a traveller. Because after all, if that were the case, if it were intended to extend that far, there would have been no purpose in singling out a more limited class, that is those who have ceased to travel permanently, but by reason of particular factors. It would extend, for example, if it was simply a question of being able to point to a family tradition of nomadism, it would extend to anybody who had chosen, for whatever reason, to give it up. So it clearly can't, and no one is suggesting that PPTS, that these more recent statements of policy, PPTS 12 and 2015, had effect to create that major extension in the embrace of planning policy for Gypsies and Travellers over, for example, the most recent statement of policy in 2006, or indeed Circular 1 of 94. So the concept.
So are the words traditional and redundant in your?
Well, there may be an element of tautology there, and that wouldn't be the first time that one has seen that in a statement of policy. But certainly, in my submission, the essential ingredient of the aim is to facilitate not only traditional but nomadism. In other words, it is intended to embrace provision for those who are nomadic, either actively or will resume nomadism.
Okay.
Right.
Otherwise, it really, if one reads satisfaction of either one or the other, if you like, was good enough to fall within the government's aim. Well, plainly, the annex, the definition of the annex on that basis is completely inconsistent with the stated aim.
Yeah. Well, yeah, I mean, the focus of the policy is on nomadism as such. Insofar as there is a broader frame, if you will, including traditional way of life, which goes further than mere nomadism, if you will. Presumably that is covered, you say, by the submissions you were making earlier about Article 8 and so forth.
Yes, yes. It's what's in some of the cases has been referred to as the cultural aspect of the protected characteristic.
Well, the fact is that, for example, Mr. Willers was recalling yesterday
the aversion to bricks and mortar, that kind of thing.
yes, but also the arrangements for living, if you will.
Yes.
As a broader concept.
Yes, although it is the PPTS doesn't give any detailed guidance on what will be necessary by way of facilities. But plainly, if one is travelling nomadically in the sense that the Court of Appeal, this court, understood that concept in Wrexham, a necessary component of nomadism is that one is travelling for work, and therefore one needs to have within one's plot space and the facilities to accommodate your working requirements. Whereas the analysis is you don't need those if you've ceased actively to travel nomadically. Essentially, then you need a home.
Right. So, how are we getting on?
Well, I just wanted to show you, for your note, just to give you the references to Basildon and Collins.
Yep.
Basildon is the case which deals with personal circumstances. You have that in, it's at tab 22.
Yeah.
This was a case involving a Greenbelt, a Gypsy and Traveller site in the Greenbelt. Decision of Mr. Justice Ousley. The inspector had acknowledged that the applicants in that case had personal circumstances that weighed in favour of the grant of permission, but nevertheless has found that on balance permission should be refused. His recommendation to the Secretary of State, it was a Secretary of State case, his recommendation to the Secretary of State was on that basis. Secretary of State disagreed and granted permission, focusing very much on the personal circumstances as the decisive factor. See page 696 at quoted paragraph 15 for your note.
Yeah.
The issue raised by the council is encapsulated in paragraph 3 on page 694. The submission was that the personal circumstances of the family were immaterial. And Mr. Justice Ousley's rejection of that submission is at paragraphs 33 and 34 on page 699. And his reasoning on that point has, as far as I am aware, never subsequently been doubted.
I'm sure it's my fault. Just tie that into this case in a
well,
sentence.
it substantiates the proposition that one of the factors that will remain, will have to be considered, depending on the facts, in a non-PPTS 15 Gypsy and Traveller application will be the personal circumstances.
Oh, part of the panoply.
Yes, yes. So it substantiates that, the materiality
Yes.
of that factor. Insofar as the best interests of the child are concerned, you have in the papers, in the bundle of authorities, the Collins case, and that's at tab 16. For your note, the head note, and paragraph 1 of the holding encapsulate the proposition, which is that the child's best interests are not only a material consideration, but should be, at least in principle, a primary consideration in any case where the interests of children are at stake in the planning decision that's at hand. And in the judgment of Lord Justice Richards, the relevant paragraphs under the heading General Approach are paragraphs 7 through to 11 on pages 455 to 457 of the bundle.
Yes.
Mr. Willers showed you Chapman for the positive obligation, paragraphs 73 and 96. I don't need to take you to those again. And the other point in relation to the case law, Mr. Willers retorts to my argument, my reliance on the broader planning context insofar as it's set by the NPPF, by the framework, was that then gives rise to thiminos discrimination, because it is discriminatory to see permanently settled ethnic gypsies as indistinguishable from other members of the settled population. The distinction that argument is overcome by the very same point, by resort to the materiality of personal circumstances, the public sector equality duty, the Chapman positive obligation, and so on. And as my lord will know, it is enough that those various considerations are in principle to be considered and weighed in the balance in any given planning decision. There is no guarantee of outcome. What matters for the purposes of my argument is that they are factors that, as a matter of law or policy, the decision maker will have to take account of and evaluate alongside the relevant provisions of national policy. And you raised with me yesterday, returning on that thought to the present case, and you raised the question as to whether, if one looks at those paragraphs of the inspector's decision which draw the planning balance, whether in fact it is conceivable that she might have reached a different decision, that is to say, to have decided to grant planning permission either permanently or on a temporary basis, had she addressed the case on the basis that the applicants were within rather than without the scope of PPTS 15. Yes. And your lordship will have had in mind that we are in Section 288 territory. Yes. We are in the context of the courts, the relief available to the court, essentially being to quash yes. And the simplex principle, which says that if the court is persuaded that even had the inspector not been, for this purpose, guilty of the error of which complaint is made, that is to say, had she applied PPTS 2012 instead of 2015, in effect, in this case, that she would, is the court nevertheless persuaded that she would necessarily have reached the same conclusion? The burden is on me to persuade the court that that is so. I say straight away, that point is not one that I have taken below, but nevertheless, it is a relevant consideration. It's one that the court will need to grapple with in my submission, if it is in order to decide whether to grant relief. And I do invite the court to consider whether, having regard to the inspector's reasoning, this is a case where it can say with confidence that the decision would necessarily have been the same. None of that will disable the court from addressing the issues raised by Mr. Willers in relation to the policy and whether it does, on analysis, display a legitimate aim, and whether it does, on analysis, display whether it can be said on the evidence that in seeking to fulfil that aim, the impact on those acknowledged to be affected by it in a discriminatory way, that effect will be disproportionate.
What if
But
we did that? The observations we chose to make about the policy would be able to.
They would be able to.
But they might be considered to be of some significant weight.
Yes.
By the Secretary of State. They might.
Yes.
Given that the matter has been fully argued before us.
Yes.
So just so that I'm clear and understand that, so you're saying that we could conclude that Mr. Willers has made out one or more of his grounds of appeal against the judgment of Mr. Justice Pepperall.
Yes.
But you would still ask us to consider whether or not that would have or might have had an effect, could have had an effect on the inspector's decision.
Yes, I mean, in very stark terms, it would be open to the court to conclude that in relying on a policy that this court found not to have been to have been promulgated in breach of Section 19 of the Equality Act, the inspector had, through no fault of her own, as it were, been guilty of an error of law, but that nevertheless, had she not been guilty of that error of law, she would have reached the same decision.
And that's not something, unless I've missed it, and I could well have done, but I don't think that's something Mr. Justice Pepperall addressed.
No, he didn't consider that, and I freely acknowledge I didn't ask him to do so. But in consequence of, it arises because this case, although the focus of this case has been on the legality of a policy published in 2015, that issue has arisen in the context of a planning appeal decision and a challenge to it in 20.
Well, it's a matter we're bound to consider because the relief, albeit confined to that particular form of remedy,
Yes.
is nevertheless discretionary in any event.
Yes. That I think is. I really must stop. But I've summarised. I haven't taken you directly to the paragraphs in my scouting argument that which set out my submissions on ground 4, but I sought to bring out the principal points, and I have made reference to a number of the documents in those paragraphs that you've been shown. I would invite you, when you look at the consultation document and the response, particularly the response, which you remember you were shown at pages 266 following, just to remind yourself of not only the government's settled position after consultation, which was set out in section 3.6, 3.7 of that document on page 270, but also to remind yourself of the of section 2, which gives the overall summary of responses, and also, as my Lord Justice Holroyde did, to look at the annex, which summarises the response to particular questions. Yeah. You will find minutes of the various meetings between the department and representatives of the Gypsy and Traveller community. You'll find those minutes, which form part of the consultation process, in the papers. They are included at pages 254 through to 265 in the supplementary bundle, and they are the points made about the proposed change to definition very much anticipate the concerns that have been the basis for this this case. So, Lord, we've ranged rather widely across various topics this morning, but I hope that my submissions are sufficiently clear, and unless there's anything else.
Thank you very much, Mr. Mould. You're being passed a note from behind, so you may want to look at that.
Oh, yes. Okay. I'm told that that there is monitoring at local level, not national level, and there's a reference to that in the Commission report that you were shown yesterday. I've been asked to draw attention to pages 298 and 349.
298, 349.
Oh, I see. I think it's. Yes, I think the point that's being made is that one can discern from this report from 298 page 298 and following that certainly some authorities at local level have sought to understand the position in relation to both of those distinct streams. That is to say, PPTS 15 Gypsies and Travellers and non-PPTS 15 ethnic Gypsies and Travellers. But I don't think that let me put it this way: it's not my case that there is that there is evidence before this court of systematic monitoring at national level in the way that which appeared in the earlier documents to have been foreshadowed.
But Mr. Mill, thank you, and thank the gentleman behind you for drawing that to our attention. And insofar as I said, it didn't appear that there had been any review. If these documents indicate otherwise, then of course my observation needs to be modified to that extent. So thank you for that.
Thank you very much.
I'm grateful. Thank you.
Yes, thank you very much, Mr. Mould. Thank you.
My lords,
Mr. Willis.
there is quite a lot to cover, but I will do my best to cover it before lunch. So
Yes, well,
That's all you've got.
that's what we'd like you to do.
Can I
In terms of time,
Yes.
You've had longer than Mr. Mould anyway.
Thank you for pointing
That would
out.
be my advice to the presiding judge.
Would it indeed?
The advice
From the timekeeper.
and I heed the observations. So I
But seriously, we don't want you to rush.
No, certainly, but I will do my very best.
We are prepared to sit a little after one.
Thank you, Martin. So, just dealing with the last point first, there has been no review. There is no central government monitoring, simply no evidence of it before this court. The best evidence we have is in the Equality and Human Rights Commission report, and you've already been taken to that. Can I perhaps, with respect to my own friend, inject a dose of reality into the proceedings by going back to the question, what does PPTS do? It's a positive measure, a positive modality. It promotes and facilitates Gypsy and Traveller site provision. What was the reason and what was the effect of excluding certain people from the PPTS? The aim? It was to make it harder for those people to obtain planning permission. It was the whole point of the change to the definition. We can see that in the documents to which my learned friend has just taken you, the equality statement. But it's also perhaps, and it's just for your note, my lords, I don't have perhaps time to take you to them, worth reading also in the supplementary bundle, pages 155 of the January 2015 Public Sector Equality Duty Analysis, and page 194 of the Equality Statement, which makes reference to reducing competition. If you remember, we had a discussion about the fact that the exclusion of those who were too old or too ill to travel from the definition would have the effect of reducing competition for much sought after and perhaps rather rare Gypsy and Traveller site provision. The point is that if Gypsies and Travellers could obtain planning permission, and this is a point taken up, I think, by my Lord Justice Coulson, as easily as they can, and I say easily in inverted commas, with the benefit of relying upon PPTS, if they are to rely instead on the whole panoply of points raised by my learned friend, then the whole rationale underlying the change to the definition in PPTS would be pointless, would be nonsensical. And how on earth, if it's right that gypsies and travellers who are too old or too sick to travel can nevertheless obtain planning permission with the same chances of success, because one has to think about eliminating the disadvantage. We're dealing with discrimination under Article 14 and the Equality Act 2010. If they are to effectively be able to have their accommodation needs met, these most vulnerable of a vulnerable community, by reference to Article 8, personal circumstances. Best interest of the children probably wouldn't come into it, but we've had reference to that too. Then how on earth is the definition change going to address the resentment that apparently exists amongst certain members of the community, the wider Severn community, reflected in the consultation response? Because surely, again, going back to that figure of 100 gypsy pitches, there are going to be 100 gypsy pitches if it's all going to work out swimmingly, as my learned friend Mr. Mould suggests. They're just going to be provided by two separate means, one by the MPPF, the other by PPTS. And when one then looks perhaps at the benefits arising from the arising from the ability to rely on PPTS, and have regard to those benefits when it comes to the decision of the inspector, and we've heard my learned friend make a simplex point, and frankly and rightly acknowledge that it hadn't been made before the court below. One can see from the decision letter, and it is important because your lordship will have to consider this for yourselves. You have a power to quash, but it's a power that must be exercised appropriately, and a discretion not to do so. But if one turns to the decision letter in the core bundle, page 358, one can see immediately how PPTS might have helped Mrs. Smith and her family. In paragraph 18, and remembering that this is a case involving a site in the countryside, but not in the greenbelt, not in an area of outstanding natural beauty, not in any area that was designated for its protection. But in paragraph 18 of the decision letter, page 361, the inspector rightly acknowledges that PPTS does not rule out traveller sites in rural settings, although it requires that the scale of such sites does not dominate the nearest settled community. Given the scale, she says, size and scale of the neighbouring villages, there is no suggestion that the development dominates those communities in visual terms, or places an undue pressure on the local infrastructure. Now that acknowledgement relates to a particular paragraph of PPTS, which you'll find in the preceding tab at the core bundle. And it begins PPTS at page 346. And it's a reference to policies which clearly show that traveller sites in the countryside are acceptable in principle.
Sorry, which page?
Yes, sorry, forgive me. Page 352.
352, thank you.
Is a specific policy I'm going to take you to. Under the heading Policy C, sites in rural areas and the countryside. Paragraph 14. When assessing the suitability of sites in rural and semi-rural settings, local planning authority should ensure that the scale of such sites does not dominate the nearest settled community. And you'll see that that is exactly the point that has been made in paragraph 18. And by the time then the inspector comes to the question of whether or not the appellant falls within the new definition, as she does later in her decision, paragraph 39, page 364. That policy in paragraph 14 of PPTS becomes irrelevant. Instead, Mrs. Smith, as my learned friend suggests, Gypsies and Travellers in her position will have to do so, and can do so, has to rely on policies in the National Planning Policy Framework. Now, we don't have the relevant policy relating to development in the countryside in the bundle, certainly not in terms of the full MPPF. We have a section of the MPPF in the bundle of authorities, which my learned friend took you to, but it stops, I think, at paragraph 78. Dr. Ruston refers to paragraph 79, though, in his witness statement. It begins at, in the supplementary bundle at page 12, and he sets out paragraph 79 at his paragraph 15, at page 15. The MPPF has been revised, as your Lordships will appreciate, since that which we've included in the bundle as a 2021 version now. And so the paragraph numbers have moved on slightly. And paragraph 79, as I said, hasn't unfortunately been copied for your Lordships, but it can be, I'm sure. Or
Yeah,
the equivalent, which is now paragraph 80.
Yeah.
And the point about this is that paragraph 79 says that planning policies and decisions, not traveller sites, but planning policies and decisions relating to other types of development should avoid the development of isolated homes in the countryside unless one or more of the following circumstances apply. And then we'll see the essential need for a rural worker in subparagraph A, optimal viable use of a heritage asset, paragraph B, reuse of redundant and disused buildings, C, development which would involve the subdivision of an existing residential dwelling, D, and then design of an exceptional quality in E. Those exceptions, you'll note, don't include sites for non-PPTS Gypsies and Travellers, but will give non-PPTS Gypsies and Travellers an immediate problem, because having previously been able to rely on paragraph 14 and the general policy, which is permissive and promoting of Gypsy and Traveller sites in PPTS, the Gypsy or Traveller relying on the MPPF is faced with paragraph 79, or what is now paragraph 80, and a clear conflict with National Planning Policy Framework guidance. So that in itself puts Mrs. Smith and others in her position in a much more difficult position, as indeed the policy change was designed to do, make it more difficult for Gypsies and Travellers to obtain planning permission. And so we say that that in itself is a point which clearly undermines any argument put forward by my learned friend as to whether the inspector might have nevertheless reached the same decision had she concluded that Mrs. Smith fell within the definition. I hope I put that around the right way. The other point, and it's perhaps a simpler one, but it's a point picked up by the learned judge in the court below, is that if one goes back to paragraph 51 of the inspector's decision, one can see on page 367 her saying this: since a further temporary consent would relate to the occupation of the site by Gypsies and Travellers who met the planning definition, it would provide no certainty for Mr. and Mrs. Smith, precisely because she has already concluded that Mr. and Mrs. Smith don't comply with that definition. And I say that it was referred to by the learned judge. The learned judge, paragraph 94 of his judgment, which you'll find back in the beginning of the core bone at page 31, was dealing with a ground of appeal which is not now before this court, where it was alleged that the inspector had gone wrong in her conclusions as to the grant of temporary planning permission. And the learned judge says at paragraph 94, in my judgment, there's no proper basis for inferring that the inspector fell into such fundamental errors. On the proper construction of the decision, the last sentence of paragraph 51 was a shorthand way of saying that in any event, even if she'd been minded to grant a second temporary planning permission, the inspector would have imposed a condition that the land be occupied only by gypsies and travellers, as defined in the then prevailing PPTS, and that such condition would not provide any certainty to the Smiths in view of her earlier findings that they did not meet such definition. That, in my respectful submission, is sufficient for the purposes of the court in determining whether or not there was the decision itself was one which would nevertheless have been made, even allowing for the error which we argue is entailed in applying a policy which is discriminatory. Thank you, my lords. Then I move on to the next point, which is linked to my learned friend's arguments about the panoply of, as it were, arguments that could be put before an inspector or a court on behalf of a non-PPTS gypsy or traveller. And he says that that entails the decision maker having regard to matters which perhaps couldn't be advanced by a member of the settled population. But one has to remember that the discrimination and the disadvantages that a non-PPTS gypsy or traveller experiences when compared with the settled population is one thing, but actually the planning policy definition puts non-PPTS gypsies and travellers at a disadvantage, not just in relation to the settled population, but also to other members of the gypsy and traveller community who do fall within the definition, that being the younger members of the population and those who are not disabled. It works in two ways. And so when it comes to the tilted balance test, if I can put it that way, or certainly the question of whether or not applying a universal application cures the discrimination, eliminates the disadvantage, and I'm taking a reference to Lord Justice Lewison, paragraph 86 in the Ward case, as my prompt for that point. The reality is that the PPTS gypsy or traveller will be able to rely on Article 8, on Chapman. They've got children, the best interests of the child, their personal circumstances, their cultural aversion to bricks and mortar. Just as the elderly gypsy or traveller will be able to. That universal, as it were, panoply of arguments does not redress the balance for those who no longer fall within the definition, the elderly and the disabled. Forgive me, my lords, I'm just checking through my notes. Without taking you back to it, my lords, I just remind your lordships of the judgment of Lord Carr in the Brewster case, paragraph 48, where he makes it clear that the justification under Article 14 requires more than simply respect being paid for Article 8 rights. It requires equal treatment. And that is a point which not just backs up the tilting of the balance point that I've just made, but also undermines, with respect, my learned friend's arguments about the Wrexham case. As my learned friend readily acknowledges, Article 14 and the Equalities Act 2010 were not mentioned, but then one knows that the Equalities Act 2010 post-dated that decision, so that's not surprising. But Article 14 doesn't get a mention, and Article 14 was quite clearly a right which formed part of this country's legislation, given that the Wrexham case post-dated the enactment of the Human Rights Act, 1998. It would have been open to the respondent in the Wrexham case to raise Article 14. I don't know why that wasn't raised or by any of the parties, but the fact is that Wrexham is not binding on your lordships in relation to the question of justification under Article 14. And more to the point, or perhaps in addition, it related to a specific definition, not the definition we're now dealing with, a definition which was to be found in statute. Here we're dealing with a policy definition in a policy which once provided for gypsies and travellers who had retired from travelling on grounds of ill health and old age. And that positive modality has been taken away from them. We're in a different ballpark with respect to our own friend than that before their lordships in the Wrexham case. It's a historical decision, it's a decision of note, it certainly assists with the understanding of how the definition of gypsies and travellers has evolved over the years, and indeed Mr. Justice Pepperall summarises that history in his judgment too. But it, in my respectful submission, takes your lordships no further in determining whether or not this policy definition change has been justified. Now, my understanding is that ground one of the grounds of appeal has been conceded, but I might be wrong about that, but it seemed to me that it had been, and that my learned friend accepts that Mr. Justice Pepperall went wrong when applying the Christian Institute test, and that it's for your lordships now to consider afresh grounds 3 and 4.
Well,
Not
Mr.
seeing
Moore
Mr.
did
Lord
not
jump up.
formally concede.
Well, I'm
ground one.
asking perhaps whether or not
He said that
That's what
he said that effectively the test the judge applied was a paraphrase of Lord Reid in SC.
Yeah.
So he didn't concede that. He did say if he was wrong about that, and we thought ground one was right, then we would then obviously move on to ground 3 and 4. And he also said if we thought the judge had not approached that in the right way, because for example he hadn't picked up that it's the measure, not the policy,
Yes.
that we should redo the justification exercise. And the submissions he made yesterday and today were all about why the justification exercise was made out. I hope I paraphrased him correctly.
Well, I'm going to say no more about it, my lord, because you've got my submissions on ground 1 and indeed on ground 2, and the relevance of race in this case, bound up as it is with the cultural tradition of living in caravans. As to unintended consequences, my lord, we focus really on that that shocking, I've suggested, situation of accrued rights being taken away. And my own friend has suggested, well, it might be a matter of enforcement, and that an appropriately advised local authority might think very long and hard before serving a breach of condition notice or an enforcement notice. But in fact, the unintended consequences, if they were unintended, and I noted Justice Coulson's reference to the fact that, by virtue of the definition being applied in Gypsy and Traveller accommodation assessment processes, the numbers have reduced quite dramatically. And whether that's unintended or not is another matter. We don't have any evidence. I can't say either way. But it's not just a case of accrued rights for those who live on sites which they own that would be potentially at risk. But I made reference to all those who live on local authority run sites, rented sites, with the same requirement that those sites are provided for those gypsies and travellers who comply with the definition. And the same applies to rental sites on private land. Local authorities may not want to step in and force those that have their planning permission for their own sites, but they may come down harder on landlords who appear to be renting pitches to those who no longer travel because of old age or ill health, when they are perhaps in a position where they have to enforce against families who are on the roadside and need spaces for them to move to. So what I can say in conclusion is that there are a number of unintended consequences. None of them were considered by the government in what, with respect, I would suggest was a woeful assessment of the impact of an amended definition. And that just underpins my point, which is that the justification or purported justification for the amended definition is as flimsy as I suggested yesterday, and certainly not the sort of assessment that one could possibly say amounted to objective justification. An objective justification to or for discrimination against those in the vulnerable community of gypsies and travellers who are most at risk, the elderly and the disabled. And my lords, can I briefly go through very, very quickly a few of the points made by my own friend this morning.
Right.
And I'm not going to cover any grounds which I've already referred to.
Right.
One thing that my learned friend suggested was that there's a real difference between nomadic gypsies and travellers and those who have ceased travelling for an economic purpose, because there's no need to store work implements and the like. They might need a touring caravan. We have no evidence that any of this submission made by my learned friend formed any part of the assessment made by the Secretary of State before adopting this definition change. And the reality is I can make the opposite submission, which is that 9 times out of 10, gypsy and traveller sites are granted permission with a condition that no work materials, tools and the like are stored on the ground. They have to be kept in the vans. Touring caravans are not the sort of accommodation that is the exclusive use of those that travel for work. Elderly gypsies and travellers, disabled gypsies and travellers live in touring caravans just as readily as those who travel for work. Give me a moment. One other thing that my learned friend said about Wrexham was that the Court of Appeal looked at the case of Chapman, which itself looked at Article 14. But you'll note that in Wrexham there's no reference to Article 14, and indeed in Chapman, the European Court of Human Rights did not address the policy definition. Mrs. Chapman was actually entitled to rely on the then circular, one of 1994, because she complied with the definition. Ultimately, she was granted planning permission, but that's another story. So as I said, there's absolutely no basis for your lordships to consider yourselves bound by the Wrexham decision. Here we're dealing with a positive modality case. We're not dealing with a statutory definition. And my learned friend took you and commented and referred back to a passage in Lord Reed's judgment in the SC case, which you remember it exhorts this and other courts to take care when considering Article 14 cases. It's at page 130 of the judgment of the Supreme Court, paragraph 162. In that paragraph, begins at B on page 130, Lord Reed said, in practice, challenges to legislation on the grounds of discrimination have become increasingly common in the United Kingdom. They are usually brought by campaigning organisations which lobbied unsuccessfully against the measure when it was being considered in Parliament, and then act as solicitors for persons affected by the legislation, or otherwise support legal challenges brought in their names as a means of continuing their campaign. The first thing to say is we're not here challenging legislation. This policy has not been through Parliament.
And the interveners are campaigning groups, but you're not representing a campaign.
I'm not instructed by the campaigning group. Rightly, they were granted permission to intervene, but I'm representing a victim of the definition, and doing so in circumstances where she wasn't involved in any lobbying of Parliament. I don't believe she was involved in the consultation process either. Indeed, the first she knew of the definition change was when she was involved in the planning appeal process. Now, the exhortations there, and your Lordship will bear them in mind, do not, in my respectful submission, and ought not, in my respectful submission, to lead your Lordships to, as it were, avoid what we say is the appropriate course of action for this court. That is to quash the inspector's decision, not because of any particular fault in her application of the policy, but because the policy itself was tainted by discrimination. And that your Lordships, when doing so, explain why, in your Lordship's mind, in your Lordship's judgment, this policy definition was unjustified from the evidence before you. Thank you, my Lord.
Thank you very much.
Forgive me, my Lord, one point. The paragraph 80, my learned junior indicates that the MPPF is in fact in the authority of
Ah,
Parliament.
right.
At page 709. I'm pretty sure it hasn't been amended to include traveller sites, but or non-PPF.
No, well, we
but
can,
you can
if
see
need
that.
be, we can check that. Yeah. All right. Fine. Thank you very much.
Thank you.
Mr. Lewis. Well, we're very grateful to Council and those who assist Council for the care taken in assembling and presenting very clear written and oral submissions. It will not surprise anyone here, or indeed remotely, to know that we shall reserve our judgments. A draft of our judgments will be circulated in due course for typographical and other minor factual corrections. At the same time, we shall invite the preparation by the parties of a draft order. Any submissions relevant to the draft order should be submitted to us at the same time. Thank you.
Thank you.